Well, you've separated, but luckily you and your spouse agree about everything to go into your separation agreement. As your situation seems simple, you may be thinking about writing your own agreement or completing an online template. Is this a thumbs up or thumbs down type of idea? A separation agreement is a complex legal document with both short-term effects and long-term consequences that reach into your retirement. Being amicable is a great start, but it won't ensure that your drafting is done properly. And even smart people leave out crucial details and make errors with legal wording. Have you ever heard the term, "I've really stepped in it," or "this situation is going up in flames," or how about, "I tried a shortcut and it blew up in my face"? You are making big life decisions right now, and we don't want you having these thoughts about your separation agreement. So let's talk about the pitfalls of a DIY separation agreement. If you are a parent, you'll need crystal clear expectations and communications to prevent friction in your relationship with the other parent. Homemade agreements often leave out important parenting issues, which will force you to address misunderstandings and mismatched expectations continually as they arise. This can cause tension and aggravation, which will be stressful for both you and your children. A separation agreement must be based on full financial disclosure. If this hasn't been completed properly, this could be grounds for your spouse to have the agreement set aside by the court. How can you make financial decisions going forward if you can't count on your DIY separation agreement? The binding nature is precisely the point of getting the terms documented. As part of your agreement, you may be refinancing your existing mortgage, applying for a new mortgage, or refinancing a car loan or other personal loans. Most financial institutions will not qualify you for financing if you have a DIY separation agreement. They are unwilling to take on the risk of lending on that basis because they know that these documents are so unreliable. Pension division is a finicky bureaucratic process with specific requirements. If you don't get it right, you may not be able to complete your pension division. RRSP transfers between spouses may occur tax-free if certain documentation and timing requirements have been met. If this is done incorrectly, you may have tax payable that you otherwise wouldn't have had to pay. Child support and spousal support are enforceable when the terms have been properly determined and drafted. Again, you want to make sure that you can rely on your agreement, so it is important to get it done right. We all get help for the important matters in life. Do you do your own dental work? How about your own electrical repairs? Did you write your own will? Sometimes an expert is required to get a job done properly. Maybe you're thinking that you can write your own agreement and have it reviewed by a professional. Unfortunately, that's not the case. Most lawyers and family law mediators will not review a DIY separation agreement because they are overly problematic. Well, now maybe you're thinking you can just have a notary legalize your document for you. Unfortunately, no again. Notaries are not allowed to witness separation agreements. Another important issue to consider is that there are legal deadlines to address a number of family law issues, after which you could lose your entitlements. The verdict on DIY separation agreements is obviously a big thumbs down. So what's the solution if you don't want lawyers and months of adversarial back and forth? Our innovative and streamlined separation agreement process is designed for situations like yours. We have a flat fee, flexible daytime or evening scheduling, and work with clients across British Columbia. Go to modernseparations.com for more information.